Ladies and gentlemen, welcome to another edition of HR Fridays. Friday the 11th of December 2020, our last for this year. My name is Clint, Managing Director of On Demand HR. Once again, we're here to present a topic. Today is a special edition. We're going to talk about alternative IR reforms. I've been looking at these IR reforms recently that the government's been talking about. I've been seeing the headlines on it. People carrying on about these things being significant. My view is that they're quite underwhelming, actually. There's not really much change at all. There is some tweaks, but nothing that's of any great amount of substance. So I'm going to talk today and just give my views about what some alternative IR reform should be. So hopefully today's session will be engaging, controversial, and entertaining for everyone listening in. The whole purpose of HR Fridays, for those who haven't joined us before, is to provide businesses, other organisations, professional advisors, and our associate members advice, which is reality. Today, obviously, is a bit more of the speculative side. We're getting into areas of possible IR reform and making suggestions. So today is a little bit different from our normal segment. Obviously, in more general terms, with On Demand HR, we've been in the Fair Work Commission many times. We've done many workplace investigations. We've dealt with the Fair Work Ombudsman many times. This allows us to provide real perspective to our clients, not just theory and scare tactics. www.ondemandhr.com.au. So let's get into our special edition today on first of all, the IR reforms that have been proposed. And then I'm going to talk about some alternatives and some things that the government should really be thinking about. Okay, let's get into it. So first and foremost, what are the changes that we're about to see? Well, my view is that there's not really that much we're going to see that's of any great value. We're going to see a bit of a change in respect to the definition of casual employment in respect to WorkPack and Rosado and Scheme versus WorkPack. Those were the cases where casuals double dipped effectively. They received casual wages but then claimed leave entitlements. So the Act is going to now deal with casual conversion after 12 months, which pretty much happens in most modern awards anyway. They're now going to make this part of the Fair Work Act, as I understand it. There's going to be some provision of a casual employment statement to new employees to be prepared by the Fair Work Commission. So, look, there is a little bit around this. There's a little bit of a definition change. They're still talking in these vague and ambiguous terms, about is the employment ongoing or not and this sort of stuff. So, again, I see this as pretty low ball sort of stuff. In terms of the compliance, so small businesses can be fined more now for underpayments, as can medium business and as can large businesses. Look, I won't spend a lot of time on that because, quite frankly, I can't see why any of this is any good for the workplace relations system, how this is helping businesses that are struggling with COVID. I mean, I really don't understand the logic of why this compliance stuff is being put forward at this particular point in time. Is it a trade-off for other things that have been agreed to potentially? But I really just don't see the benefit of this. And, we're supposed to be in an environment where employment's struggling, and yet we're proposing things that are essentially just going to make things more difficult for employers in general. So severe cases can attract up to 4 years of jail time. I mean, who knows? Will the ambulance chase lawyers be simply threatening jail time now to companies when they write about underpayments? I mean, we'll just have to see how that all plays out. Other changes that are going to happen are going to be in respect to some of the industry awards. So there's a whole bunch of industry awards that are in that list there. There's going to be some minor changes around part-time employees can agree to work additional hours without incurring overtime penalties. I mean, honestly, big deal. These sort of situations, I mean, the concept of part-time employees getting overtime for working less than 38 hours anyway is absolutely ridiculous. So, I mean, this sort of situation where part-time employees can be working 20 hours a week, or I can agree to work additional hours without incurring overtime penalties. This sort of stuff is, lowball stuff, really doesn't make many changes. I mean, a lot of part-timers are already agreeing to these sorts of things through various different contractual arrangements. You can have flexible work directions to employees to vary the location and duties, but not the pay rate or the hours. I mean, again, big deal. This sort of stuff, most of the JobKeeper-enabled directions were relating to hours. Location, all right, your employees can continue to work from home, or they can continue to work from another office. Big deal. They can continue to work other duties. Big deal. None of this stuff makes any real value to to organisations in the real world, and certainly not, really an SME world. There is also the ability for loaded rates to allow employers to pay effectively an all-purpose hourly rate. Not 100% sure how that's going to work yet, but once again, nothing of any great significance. So all the headlines you've heard about these being significant IR reforms. I mean, talk about an era where headlines are just sensationalized for the purposes of clickbait. I mean, these reforms couldn't be further from the truth in terms of them being described as significant. So let's get into the interesting part of the session now, where we talk about some alternatives. What sort of IR reforms should we see? And I'm just going to give an opinion on 6 different IR reforms I would like to see. This is based on my experience with dealing with over 400 business clients in the small to medium enterprise space over the last 11 years. So let's get stuck into it. So the first reform I would like to describe as the casual employment convert or shut up principle. And that is simply this, is that just make casual conversion the same as the minimum employment period. So 6 months, less than 15 employees, 12 months, 15 or more employees. So I'm even prepared to go lesser on the casual employment conversion. That's probably something that the unions would welcome, that the casual obligation for conversion is 6 months rather than 12 months. And I agree that it should be just part of the Fair Work Act and not the modern awards. It's unnecessary to have various different modern awards with different provisions. The test that I think is important is that conversion must be based on a certain minimum number of hours being worked over that 6 months. So I would say something like 15 hours a week. So if you don't work 390 hours in 6 months, bad luck. You can't request conversion. I think that this whole notion of regular and systematic and trying to define what's ongoing and what's not, again, this is just leading to grievance. It's just leading to lawyers and leading to other parties disputing these things in courts, in the commission. And this doesn't do any good for small and medium business. Put a number on it. Put a number of hours on what is required as a minimum to request conversion. I mean, if you're not working 15 hours a week as a casual employee, well, you know what? You shouldn't really have the right to convert to anything more substantial than that. I'm sorry, but that's this rule on hours would reduce would remove the ambiguity and would give people certainty around when you can and can't convert. I guess to work in conjunction with this, if you don't hit the 390 in the first 6 months, well, then maybe later on, if you hit the 390 in a 6 month period or in the next 6 months, you can request conversion and something like that. So again, I think that would be a good change, give certainty, would remove the need for all these, lawyers and others to get involved and make massive disputes about these sorts of things. So that is my first reform. And look, the only other principle as part of that is that none of this double dipping around casual loadings. If you receive a casual loading, you either don't convert and you keep your casual loading, but you shut up in terms of trying to claim leave entitlements later. I mean, this whole double dipping has to end. It's as simple as that. And employers can't have the uncertainty around these things going forward. So that's the first reform. The second is part-time provisions. So eliminate all overtime provisions for part-time employees. The concept of part-timers who work less than 38 hours getting overtime is ridiculous. The NES doesn't require it. And this is something where the modern awards have overreached. The modern awards have all included these provisions around, if the part-timers agreed hours are 20 and you work above the 20, well, then, that should be paid as overtime. I'm sorry, but the National Employment Standards, if you look at the core of it, it's 38 maximum ordinary hours in a week. The modern awards have overreached on this issue. And I think there's 2 ways of solving this. So one, the ideal way would just be eliminate all overtime provisions for part-timers altogether. Obviously, above 38, pay overtime, of course, but less between whatever the agreed hours is and 38, that should just be ordinary hours. Look, the compromise could be is that, well, if a part-timer agrees to work 24 hours a week and they need to work additional hours as requested, pay them the casual rate for those additional hours, which are in excess of the agreed or contracted hours. That way, the accrual of leave entitlements is still based on the permanent hours. The permanent employment's still intact. The casual rate then comes into play for any extra days that are kind of ad hoc. Obviously, parties can agree to increase the part-time hours in the future, as they may do so. So again, that would be a nice reform to see. Just again, remove this ambiguity around part-time employment and make part-time employment more flexible. I mean, we hear grievance about, oh, well, all this insecure employment, but yet, no one wants to make part-time employment flexible enough so business can use it. This is why business uses casual employment as it currently stands, because the part-time flexibilities are inadequate, and they still are inadequate even after these reforms. So this reform would certainly be better. The third reform I'd like to see is on annualised salary arrangements. And quite frankly, this reform earlier this year in March 2020 is an absolute joke. This current reform for annualised salary arrangements, or the current, should I say, provisions in place in the modern award, require the employer to have an annual reconciliation of the hours worked against the salary, the outer limits of the overtime hours that will be included, and the penalty hours that will be included, and the details of all of the provisions of the award that are satisfied. These provisions are ridiculous. I mean, small businesses aren't going to do this stuff for starters, so they're almost always going to be in breach unless they've got professional advice. And it makes no sense. It creates uncertainty with parties. What happens if the salary increases? Do you then issue a new annualised salary letter updating, what the outer limits are again? And it's just so much compliance in these situations that it doesn't make sense. What I think would be much easier, much simpler in this situation is set an annualised exemption rate for all modern awards. The Registered Clubs Award actually does this very, very well. So what I propose is that every modern award has a weekly rate. So then what you do is take the weekly rate, add 20%, and that gets you a certain level of exemptions. So if you pay a salary above 20%, more than the minimum weekly rate under the modern award, you get certain exemptions. And those exemptions might be, overtime within the usual 5 days of work, early morning, night shift penalties and general shift penalties, and maybe things like weekend penalties, but maybe not public holidays. So that's what a 20% exemption might look like. And then you have a higher exemption, which is maybe a 40%, which is like an all-in where you cover pretty much everything. So that would be all overtime, early morning, night shifts, general shift penalties, weekends, and public holidays. So have two set exemption rates, stick to them, no more outer limits, reconciliation, or those rubbish provisions that we've got right now. The exemption would be automatic based on the salary being paid. And I'm sorry, but if you're getting 20% or more than 20% or more than 40% above the award, you've got no moral basis for saying that you're underpaid wages, and there shouldn't be scope for underpayments to be brought in such technical and, quite frankly, frivolous circumstances. So that would be a great reform to see. Annualised salary arrangements put to or move to some sort of annualised exemption rate with set figures of what those exemption rates would include and cover. Let's go to small business provisions. We've heard for ages information about the small business award and that we need to have a small business award. I think there's another way of doing this. And the other way of doing this is having a clause in every modern award that deals with small business provisions. And I think, look, small business should be more around the 20 employees or less, but that's neither here nor there. The 15 or less, maybe you keep that as it is. But I have a dedicated clause for small businesses in each modern award. Have lower rates of pay. And look, I know this is controversial, but by 10 to 15%. The fact of the matter is that larger businesses, are in a greater position to afford higher wages when compared to their smaller counterparts. If it means that the businesses for, the wages for larger businesses need to go up a little bit to offset the reduction in the smaller businesses, that could be another option. I don't like that, but, that might be a compromise. The other thing as well is that potentially you could have two tiers. You might have an 80% of the full wage if you've got 10 employees or less, 90% if it's 10 to 20 employees, a little bit like how junior rates work in the award. The other option, which could work either in conjunction with this or outside of this, is as an alternative, you could have a lower casual loading for small businesses. And people, some people will scoff at this and say, oh, but you're reducing workers' rights, all this sort of thing, and this is not justified. But when you think about it, small businesses already have lower protections in some areas. So first of all, there's no redundancy pay, and second of all, there's a higher minimum employment period. So the 25% casual loading is supposed to be compensation for the benefits of permanent employment. Well, if there's no redundancy pay for small business, then how is it justified that the casual loading for small business employees is the same as it is for larger businesses? So I think there is a justification for that casual loading being reduced to 15%, maybe 12.5%, something like that. The other thing the small business provisions in the modern award should deal with is things like the flexibility on breaks. I mean, if you've got a retail shop with one person in it, a half an hour unpaid meal break might not be practical. And you know what? Might not even work in the best interest of both parties. If someone can continue working, get paid for that lunch break, and have some food and drink at their workstation, well, isn't that better than them not working for half an hour, getting paid half an hour less because of some obligation under the modern award? I think this whole notion of crib breaks is something that, sadly, we've actually seen go out of the award system. And I think it's something that should be brought back in, particularly for the smaller businesses. The hours of work should be more flexible in the small business awards. There should be a greater scope in the hours of work for those arrangements without incurring any penalty rates. So without incurring the early mornings and the night shifts. Fair enough, the weekend penalty rates, but certainly some of those ones around the pre 7 a.m. or after 10 p.m. should be scrapped for those situations. And the other thing I'd like to see in the small business award is the overtime rates either being capped at time and a half or maybe a time and a quarter, time and a half transition of some sort of kind. So again, I think those would be sensible things for small businesses, and believe it or not, would also lead to more meaningful employment for a number of those persons. Let's move on to another proposed reform. We've got two more ideas that I'm going to put out there. So the other one is around unfair dismissal. So at the moment, we've got this notion that you can apply to the Fair Work Commission for unfair dismissal, and that's basically the commission can award, up to 26 weeks' wages. And frankly, I think that for someone who's been employed for, a year, I mean, I'm sorry, but I don't care how harsh the termination is, you don't deserve to get 26 weeks of compensation in those situations. So what I'm proposing is a notion of what would be called the MCS, or the maximum compensation scale for unfair dismissal, based on length of service. So I think there should also be deductions for redundancy paid and notice periods paid to eliminate double dipping on unfair redundancies. Because what we currently have is a situation where you can be made redundant. You could get theoretically your 16 weeks for 9 years or more, plus you could get your 4 weeks or 5 weeks notice, and then still have a crack at unfair dismissal. So there shouldn't be any double dipping in this regard. At the end of the day, Section 392 of the Act currently takes into account remuneration you have earned since the dismissal, in factoring in how compensation is awarded. So what I'd like to see is a maximum compensation scale. What I've actually done is just created that scale out of thin air. I've come up with it, and it starts at 4 weeks and it goes up to 26 weeks. And the idea is that if you claim an unfair dismissal, this is the maximum compensation you can get for the period that you were employed. And what you can also do is, and this is a way of just eliminating claims for unfair dismissal altogether, is that the employer can pay the maximum compensation to an employee, and that would be a jurisdictional objection for unfair dismissal. So basically what you do is you say, right, you've been there for 3 to 4 years, I'm paying you 10 weeks or whatever the figure is, but that gives me essentially an exemption from those unfair dismissal claims, or give me a jurisdictional exemption. So the employer can essentially opt out of the employee taking the claim by paying the MCS, essentially. So again, it's an idea that's out there. It would certainly reduce the number of unfair dismissals significantly. I imagine, what's the point of spending a whole bunch of money paying lawyers, consultants, and consultants even like us who represent clients in the Fair Work Commission, when the money could go to the employees in this situation and actually, deliver some greater benefit to them if they have been terminated for whatever reasons they might be. So the other thing I'd like to see on unfair dismissal is this notion of, if I'm award covered over the high income threshold, I can still make an unfair dismissal. I mean, that's just crap. I mean, they should just get rid of this. If you're above the high income threshold of 153,000, bad luck, you can't make an unfair dismissal. Again, this creates almost a situation where as soon as someone's above the high income threshold, let's kind of conjure up an argument that someone's award covered so they can make an unfair dismissal. This is ridiculous, should be abolished. I think also, look, reinstatement should be eliminated for two reasons. Number one, it's extremely rare. It's a thing of the past. And it should always be employer prerogative to keep who it wants to provide, if who it wants, provided fair compensation is paid. So the commission should abolish reinstatement. It's so rare. I know that would probably upset a number of unions, but again, even the unions are becoming very pragmatic with this stuff these days in negotiating settlements and compensatory settlements these days. And really, do you really want to go back to an environment where an employer has literally terminated your employment and has unequivocally indicated that they do not want you to work for that business anymore? So I would abolish reinstatement and make those other changes to unfair dismissal. Certainly would reduce the number of claims, probably would reduce the importance of various people being employed in the commission, but that is what it is. So, but there are other things I think the commission could play an important role in, and that takes me to reform number 6. So reform number 6 is around general protections and underpayments. So I think, first of all, general protections claims are an absolute joke. The whole concept of that someone can commence a general protections claim based on a workplace right is a joke. It's too ambiguous. The argument can be made for pretty much anything. I've got a workplace right to do this. I've got a workplace right to do that. You can argue any workplace right that you like for the purposes of running the claim. Again, ambiguity, claims, legal action. This stuff's all dragging businesses down. And frankly, again, even for employees, the involvement and the reduction of their settlements based on parties being involved and negotiating these things on their behalf, it doesn't create a great deal of value. What I think would be good, though, is that the discriminatory-based claims continue, but under the Fair Work Commission. So the Fair Work Commission to deal with any employment-based discrimination claims in a similar way to the way that they would deal with unfair dismissals. So eliminate essentially part of the general protections. The discriminatory claims come under a discrimination-based claim or something that the Fair Work Commission would handle. They do it a lot more efficiently than, frankly, the AHRC and those bodies. I think that the use of the MCS, the maximum compensation scale I just spoke about, could also be used in these types of claims. Look, that might be resisted because of case law. I know that there is some cases, for example, you look at like the Richardson and Oracle case around, sexual harassment and the sort of money that's paid out in those situations. Look, maybe that would create a barrier to the MCS being used in a discrimination-based claim. But again, I think we need to try and have some limits on these things. We need to have, some certainty and some sort of science and a little bit of metrics around this. The longer your employment is, the more significant the dismissal is, the more significant the payment should be. But there still should be, there should be parameters around these things. Again, I think with underpayments, I think the Fair Work Commission could also handle that. My observation of the Fair Work Ombudsman's handling of this is that sometimes they are particularly keen to chase things, and sometimes they are completely not keen at all. And it seems to really vary significantly depending upon who the case manager is, or who the officer is, or the compliance officer is that's looking at it. And I've looked at the enforcement policy and I can't understand how it is applied in reality. So again, I think that the FWC process could be similar to an unfair dismissal. And I see that, look, rather than talk about harsh fines and criminality for businesses that are underpaying or that are found to be underpaying, why not just make the process easier? Make the process easier, get employees to get a result faster. That's the better outcome here, is to make these things more accessible rather than pushing employees through the courts or pushing them through a system that's not delivering results in terms of consistent compliance. Look at this as an alternative. So creating the barrier for them to get into those types of claims or address those types of matters much more simpler. So that's it for today. So that's my 6 IR reforms. I'm sure that, people who watch this back will think some of them are quite controversial. You may think some of them don't even work, but I certainly think there's a lot of merit to these things based on what I've seen. I think it would reduce so much in terms of dispute and grievance. And I think that, look, if you do look at these things objectively, there is something in it for everyone. I think that there are areas where we can increase the protections for employees, particularly around stuff like conversion, but then balance that against, things like, but you've got to do a minimum number of hours. There's got to be some sort of checkpoint of hours that you have before those claims can be made. So really appreciate you listening into today's session. Thanks very much. I've got a question here, is actually from Adam Grinberg, and we've got here a question about the establishment of uniform terms under awards would reduce underpayment claims by making awards simpler to administer also. Yeah, I think that certainly is right. I think there's work to be done around reducing underpayments, and just in terms of making them simpler. I mean, a lot of these underpayments are so technical. They're so based, and they're based on, look at the large organisations that we've had that have basically failed to essentially have compliant workplace relations affairs. I mean, it beggars belief that some of the large organisations we've heard about recently, if they can't get it right with, industrial relations lawyers, HR, dedicated HR teams, what chance in hell do small businesses have to be able to do this stuff? So a great comment there from Adam, who is also an excellent workplace relations consultant in Victoria. Thanks very much for your comments on this. And your contributions are always welcome. If anyone else has got any more questions in the last 30 seconds or so, feel free to shoot them really quickly before we head off. But once again, it's been great having you on HR Fridays for 2020. We will be resuming in the new year. I'm going to be taking a break from HR Fridays next week as we wrap up On-Demand HR's yearly works and start planning for 2021. Stay tuned for some really interesting topics. Let us know if there's any topics of interest that you would like, and we will certainly look forward to your company in the new year. My name's Clint, Managing Director of On-Demand HR. Have a great weekend, and we'll speak to you soon.